Welcome, everyone. We will begin in just a minute. Make sure that your computer is muted if it's not already. We're excited to have you here, and we will begin in just a few minutes. All right, well, we will go ahead and get started. My name is Roxy Deer. I'm the Director of Membership and Education with the Wayne County Chamber, and we are at today's business education webinar, Ask the Attorney. I'm so excited that all of you are here. As a reminder, this is being recorded and will be available on our YouTube channel and on WETV channel 20 after it will air next month. I'm excited because we've got a great attorney here today that will be giving us a lot of insight into small business ownership and all the legalities that go with that. So we will go ahead and get started. First, before we get started, I want to thank all of our attorneys, or all of our attorneys especially, but especially our sponsors for today. Peggy, you and I had one sponsor last year, and this year we have a lot more. We are so thankful. We have even added one more from last month, and that's Phillips Tube Group. So thank you to our sponsors for making this session happen today. Next, I want to introduce Peggy Cenova from the East Central Indiana Small Business Development Center. Peggy is a wealth of knowledge, and she is somebody that we love partnering with on this series. So Peggy, I'm going to hand it over to you.
Well, thank you, Roxy. This is an exciting series, and we're happy to see some people here that we hope will be very interactive and ask some questions. I think that maybe we should have Bob tell us a little bit about himself before we start. We'll just put him right on the spot.
Well, that's fine. My name is Bob Bever, and I am an attorney with Boston, Beaver, Forrest, Cross, and Sickmann. Been practicing about 43 years now, and a large portion of my practice has been business on business operations, business creation, development, et cetera. And been very fortunate to, it's funny when I go through the chamber directory, I'll go through the membership and say, yep, they're a client, they're a client, they're a client, they're a client, just to give some love to my clients and shout outs to them. I mean, we're talking about CITs from LA, Prolon, Reynolds Plumbing, Bader Mechanical, the Taco Bell KFC franchise, Richmond Casting, First Bank Richmond, BSN, Brady Ware Accounting, Kniffs, Devco, Porter Advertising, Golden Engineering, Kent's Harbor, Houston Manufacturing, and of course, my most important client, the Chamber of Commerce. So that has kept me busy, but it has given me the opportunity to be able to hopefully add some things to what this topic is today, as far as developing a business and some questions surrounding a business and how things ought to be and how you might best set yourself up in a business. So I am a Richmond native, having gone to DePaul University, then IU Law School, and have, as Roxy had indicated earlier, have had also the opportunity of being on the chamber board for, I think, half of my life. So that's it in a nutshell.
So I think we're going to move forward, Roxy. We had some questions ahead of time, but also make sure that everybody has questions. It says if you have questions for Bob, drop them in the chat. Raise your hand, we'll call on you, or don't get frustrated because we're here to answer those questions. And it's great that Bob has such a wealth of knowledge. I just was figuring out, should I call you Bob or Robert?
Oh, absolutely.
Mr. Beaver?
No, I wouldn't recognize Mr. Beaver. That would have belonged to my dad. So.
Esquire. Okay, so of course I work with small businesses every day, and I try to answer their questions, but I always preface it with, I am not an attorney. But one question we get often is, how should I choose my business structure? And I know what all the structures are, but I wonder how you address that question when someone comes to you, they're ready Absolutely. To start a business, or they
very fair question. What a good one to start out with. And your second part of that, and do I need an attorney for that? I'd recommend it only because of some nuances in here, and that's what I will go into. But let's first look at what are the possible structures that you could have. There's four primary. One is a sole proprietor, Bob Bever, and I could have an assumed business name, so it could be Bob Bever doing business as Bever Widgets, and we'll get into that when we have a later question about naming. But that's going to be your sole proprietor. If you add someone else, then you've got a partnership. That could be a wife, it could be a buddy, it could be a brother, it could be more than two people. For example, our firm, Boston Bever, Forrest, Cross, and Sickmann, is a partnership. And then our doing business is BBFCS attorneys. So a partnership is the next structure. Third one's going to be a limited liability company, LLC. Generally, it has been more recent in the last 20 years as compared to then the fourth is a corporation. The primary difference between the first two that I talked about, the partnership and the sole proprietor, and the LLC and the corporation, is for liability exposure or reverse liability protection. What do I mean by that? If I am a sole proprietor or if I'm in a partnership, I'm going to be personally responsible for the bills and debts of my company. Also, to the extent that there is somebody who is injured, I'm going to be personally responsible for any accident that's occurring. Now, you can have insurance that protects you, of course, but you're still going to come back personally. That partnership, that's one thing that sometimes is a misleading. People think that if I'm in a partnership, there's no longer personal liability. Well, one has to first go after the assets of the partnership, but if those are not sufficient, they can then go after each partner's individual assets. So there's no liability protection in a sole proprietor or a partnership. However, there is on an LLC or a corporation in that you are not personally responsible for the debts and you're not personally responsible for injuries caused by someone else associated with your company. Now, that caveat is very important. And what do I mean by that? And that is on liability protection, you can never protect against your own actions. For example, early in my career, I had some truckers who were solo drivers, and they'd come in and say, Bob, should I incorporate for my truck? And I asked them, do you have any employees that are driving your trucks? No, just me. So I said, well, what are you trying to protect from? Well, if I run into somebody, if I run into a school bus of kids, I go, if you're the driver, I don't care whether you've incorporated that trucking business or not, you're still responsible. So you can't remove the liability against your own actions, even with a corporation or an LLC. However, if it is some employee that's doing that, if they are an employee of your LLC or your corporation and they hit somebody, then you won't be personally responsible. Your business will, but you won't. So they won't get at your house, your own bank accounts, etc. So from a lawyer standpoint, the primary purpose of creating either an LLC or a corporation is for that liability protection. Now, granted, as far that also protects you from bills and creditors, unless if a creditor or a bank primarily gets you to sign a personal guarantee, then you're still going to be on the hook. And if you're a new business, new corporation, new LLC, it's likely that a bank will require that personal guarantee, at least for a few years. Also, vendors are now getting smart, if you want to call it that, in that they know that if a new corporation does not have a good track record or has just a new track record, let alone a good track record, they'll want a personal guarantee on any items that you're buying on credit. So that the liability protections is the primary reason you would go with one of those two. There are some other reasons. One might just be for PR purposes. You think that as your up and coming business, it's going to sound better to be a company, to be a corporation, to be an LLC. The other would be if you have multiple owners, it's a lot easier to create shares for them in the event of a corporation or units in an LLC rather than a multi-level partnership. Now, what do I need? A later question talks about what are the documentation for them. So I'll kind of wait until we get there. What's the difference between an LLC and a corporation? An LLC, both are going to give you that liability protection. An LLC is a little bit easier to maneuver around, mainly because it only has one or two at most documents. To get either one started, you file what's called articles of organization for an LLC with the Secretary of State. you file articles of incorporation with the Secretary of State for a corporation. Both, as those articles are the primary document. On an LLC, the only thing else you need is an operating agreement, which is similar to what would be bylaws in a corporation, but you can put a lot more in an operating agreement, such as any buy-sell provisions, who are your members, what its purpose is. So everything can go into that one document, as compared to on a corporation, you're going to have bylaws, you have to have officers, you have to have shareholders, you have to have directors on a corporation, whereas in an LLC, all you need is the members. You can choose to have what's called managers, which is another management level. Primarily, that would be as if you had 20 members in your LLC and you wanted to narrow down who are really the ones making decisions, and maybe you want 3 or 4 managers in that, but it's not required. And if you just have 1 or 2 people, there would be no reason to have managers. You just have it be controlled by the members themselves. But in the corporation, there's a lot more levels of what is required. What I have found is that in deciding between the two, go to an accountant, because there are going to be tax ramifications that would be the main difference between the two. From my standpoint and the legal standpoint, they both give you equal legal protection from liability purposes. So I will tell people after we go through the two differences that one is a little bit easier to utilize and to start up, but it's primarily going to be up to your accountant on which of those two. Now, before I end with the corporation, you may have heard of people talking about, well, I want an S corporation, which is for smaller ones. That is not something I would do. That is solely for income tax purposes. That would be an accounting decision that you file with IRS, whether it's an S corp. One does not organize as an S corp with the state of Indiana. You just incorporate as a corporation. Then your accountant will help you choose whether you want that S status, which again has tax ramifications, and you file that with IRS. So as you can see, there are differences and nuances between the different possible organizations that you have, and each one has an impact on it. So if possible, I would have you get help from an attorney and possibly an accountant as you're choosing to start a business, be it a corporation or an LLC or a partnership. So hopefully that gives some answer to that first question.
We have a question in the chat box here. So this is a surprise. And it went away, so I'll have to bring it back up here. When will the COVID liability protections recently passed by the state of Indiana go into effect?
I've not seen the bill itself from the General Assembly, whether they're going to try to make that retroactive, whether it's be going forward. That'd be something I'd have to check on.
Great. Actually, in a different lifetime, I worked for a group of attorneys, and I know the answer to every question, Bob. And it is,
wow.
It depends. It depends, right?
It depends, that's right.
I have a law degree. It depends. Okay, we're ready for question 2. What do I need to know about choosing a name for my business?
Okay. What you want to do is, if it is going to be a corporation or an LLC, a fifth one I did not really go into because it's rare, a limited liability partnership, which is a way to finance a company. Those also are filed with the Secretary of State's office. And you can do, even on your own, go to the Indiana Secretary of State's office to find out if a name is already in existence that would prevent you from using that name in Indiana for your corporation or LLC. You can do that without actually having to yet file your papers for the incorporation or the LLC, just to look for a name availability. And they're pretty good about, you can even, I've had some companies that will be Indiana Widget LLC, and then I want to start a corporation and have it Indiana Widget Inc., and both are allowed. But if it's too close, then you would need to have a release from that pre-existing company in order to use that name. Now, again, this is just showing what is allowable through the state of Indiana. There's a whole nother segment as far as trademarks that one would need to check on. Like if there's a name in Indiana, Coca-Cola, maybe there's not an Indiana corporation named Coca-Cola, but I can guarantee you won't be able to use that name because there's some company that happens to already have a trademark on that. And so you're not going to be able to do that. in order to check on that, there are ways to go to Washington if there's something. If you haven't heard about it, it's likely not to already have a pre-existing trademark. So I would go first to the Indiana Secretary of State's office, and even some of those with national trademarks have registered an authorization to do business in the state of Indiana. So that's still going to bring up a lot. Now, if you are not going to incorporate or become an LLC and are just using a partnership or a sole proprietor, but still want to use a name, you can do that. That's called an assumed business name, a DBA, a shortened version. For our firm has that. Our DBA is BBFCS Attorneys. When that happens, there is a book you have to file with your local county recorder so that when somebody does business with that company named, they know who is really behind it, be it a partnership or a sole proprietor. So those are things to be looking for when you're choosing a name. And then of course, there's a whole another segment of PR about how to choose a name, what sounds good. I would not choose the name Malpractice Inc. for our law firm, probably. So I would want you to think of what's wise from that standpoint too, as well as the legalities of it too.
Any questions on any of that from y'all?
Bob, what happens when someone wants to change their business name? Maybe instead of the Wayne County Chamber, they want to change to the Richmond Chamber or vice versa.
We've actually done that, Roxy, over the years, as we once were the Richmond. So that requires your name, your official name will be set out in your articles of incorporation, that first document we talked about. If you're going to change that name, then you file what's called an amendment to that articles of incorporation. We have done that with the chamber once and maybe twice through the years as we've wanted to further develop and expand what our jurisdiction or our customer base is.
Thanks. Number 3, what is an operating agreement? You got into this a little bit, but maybe a little bit deeper.
Sure.
And bylaws for my business. Do I need these? And can I just go online and Google it and do it myself? Because I get that question a lot, Bob.
You could try. I don't recommend that because every company is going to be just a little bit different. And as they always say, preventive medicine is so much better than getting yourself in a bind, and it's going to cost you more in the long run than spending a little money up front to have it correct. These two documents are for two separate entities. The operating agreement is solely related to an LLC, to a limited liability company. And that operating agreement is going to set out your name, who the members are, who the owners are, your principal address, the primary purpose of your company. It'll have in there an important aspect as far as what happens if one of your members dies. What happens if one of them just wants to get out? How does that buyout occur? When can the company be dissolved? What kind of voting is required? Many things will have majority vote for a lot of your day-to-day activity, but some of the major things like whether to dissolve or not, you might want a supermajority so that it requires 75% vote of all of your owners to dissolve it or to add a new person. So those are all the types of things that you're going to find in that operating agreement. Though in general, it's not legally required for a limited liability company. If you're ever going to get a loan, if you're ever going to do business with a vendor, they will ask to see your operating agreement. So in my mind, I think it's safe to just assume it is required. Now, the only time that it is absolutely required is Indiana just now created a new kind of entity called a master limited liability company. What does that mean? This is something new that allows you to kind of have subsidiaries under your LLC. Most often would be used for somebody who, let's say, has owned a lot of rentals, that they want to have a protection for each one of their houses, each one of their buildings. So they want to create a separate LLC, but don't want to go to separate operating agreements, separate articles of organization for all of those. They now allow a master limited liability company that has a name, and then you put an S at the end of that name. And underneath that, you can create what's called series that would have that name, and then the series J Street property, M Street property, whatever else. So it would look like you have one LLC, but for liability, each one is separately protected. In that instance, that master limited liability company must have an operating agreement. That's the only time it's absolutely required, but I still highly, highly recommend it for all others limited liability companies. And what I find is the Secretary of State's office has made it very easy for someone to at least create the LLC on their own. You go online, and if you choose to do this, it's fine. But on the articles that you file only requires the name, the resident agent, the address. It'll say, is this to be managed by members or managers? Generally, it'll just be your members. And they'll also say, is it a single member LLC? You can't do an LLC just being the sole owner, just like you can be a sole shareholder in a corporation. But people will do that. They've gotten their LLC in existence. But then when the bank comes, or when a vendor comes, or when somebody wants to join them, they'll say, can I see your operating agreement? And that's where people say, well, I didn't do that, because that's where it helps to have that attorney that will create that operating agreement for you. I'm sure there are forms out there, but because there are so many, and a lot of it is boilerplate, but those 5 or 6 items that can change by each company are important enough. I would say if this is your first limited liability company, get an attorney to help you put that operating agreement together. Now, let's move to a corporation. Corporation's not going to have that operating agreement, but they will have the bylaws. That is not as all-encompassing as the operating agreement, but it has a lot of the similar types of things in the bylaws as to how many directors are required, who's qualified to be a director, how are the directors elected, annual term, 2-year term, what rights do the shareholders have? Do you have classes of shares where some have voting shares, some have non-voting shares? How is the corporation going to be dissolved? But it does not generally go into your buy-sell provisions like you have the operating agreement. You would have to have a separate document with your corporation for that, as well as your original minutes for with the corporation for the bylaws. So that's one of those examples of what is a little bit more cumbersome with the corporation creation as compared to just the operating agreement for the LLC. And the law for the bylaws, that is legally required. You have to have the bylaws for a proper Indiana corporation.
Wealth of knowledge. Thanks for sharing with us all. I think that asking you a question is much easier than to go to Google because you have a little bit of history there.
Just a little bit.
Melissa, did you say, would you like to ask a question here?
Sure. Well, I have heard some discussion, Bob, among some local businesses and outside of Wayne County, as a matter of fact, on the COVID vaccinations and whether or not employers are able to require employees to be vaccinated. Do you want to comment on that?
I will comment on it. I've tried to read as many articles as I could on that. And all of the initial articles said this, that while it was still in its emergency stage, as far as being offered to the public, which I believe it is still in its emergency stage, one cannot legally require your employees to be vaccinated. Once it leaves the emergency stage, then it appears, and this is one of those where it depends, and it's going to take a while to, I think, shred out through some of the courts on whether an employer can or cannot require it of their employees. It may depend on union contracts. It may depend on prior employment contracts. It may depend on the risk you want to take on whether, because you're going to have some countering federal legislation involved here, like Americans with Disabilities Act, other things that would say, I can't, even religious act, I can't do it for this and this. So needless to say, right now, while it's still in the emergency stage, we're telling all of our clients, no, you cannot require it. Once it leaves that, we're going to have a little bit tougher decision to make. And as Peggy said, it's going to depend. And until I think there's some court decisions out there, it's still a kind of a red flag area. And I would err on the side of caution before I would start mandating it.
Great information. Hopefully that's helpful to some listening, either live right now or on WCTV later. Thank you.
Sure.
That's a great question. Bob, I'm not sure if you answered this. I was trying to listen really hard. Did you talk about if I have an LLC and I want to add another member? How do I go about doing that? Do I just call
Okay.
your office and say I need to do this?
That's right. No, if you want to add another member, it depends on what you have put into your operating agreement, how to do that. If you put, some will even say it takes unanimous vote of all of your owners, or again, in an LLC, an owner is called a member. In a corporation, an owner is called a shareholder. But the operating agreement may say that it requires unanimous consent of all current members. It may say it requires a supermajority. It may say it just requires a simple majority. And if you are already just one person, then you just have to ask yourself, do I want to add somebody? You don't have to file anything with the state to add that member, unless the new member is your new resident agent. But internally, you would want to do some sort of minutes to reflect that membership. If I have, let's say, 100 units, and again, in an LLC, they're called units. My portion of ownership is called a unit. In a corporation, it's called a share. But let's say I'm a single member and I have 100 units, and my operating agreement says that 100 is the total available units. Somebody new comes in. If I want them to be an equal owner with me, I'm going to transfer 50 of my units to them. Well, then you would need to do a transfer document showing the transfer of that 50 units to that new member. If you're only transferring 20, then it'll show 20 going to them. You can do a certificate of units. That is not as common as the certificate of shares in a corporation, but it probably is wise practice. We ought to do it more than we really do, so that somebody has a piece of paper showing the number of units they own. Oftentimes it's just in the LLC record book, but you can have that certificate showing that unit ownership. And so it would be that unit transfer. If you authorize 1,000 units, but only have issued 100 to yourself or to you and your wife, and somebody new comes in, and so it's not a transfer of your own, but it's a new issuance, then you won't be transferring any of your own, but you'd be actually given some that had already been authorized out of it. And whether you do one or the other is probably going to be a tax question on which is going to be best to create a basis for that new member, and to either have you not be paying capital gains on what you're selling to the new member or not. So again, you need a team of people, both with your attorney and your accountant, when you're dealing with some of these questions.
Thanks so much. That really, I hadn't thought of some of those things you're talking about, and I talk to small businesses every day. That's excellent information.
Sure.
So I get this a lot too. I have a brand new invention, and I think everybody's going to steal it if I don't protect it. How should I go about doing that? And also on this one, I think it's prohibitively expensive, but maybe you could talk to the expense of that as well.
Unfortunately, I probably can't, because my answer to your first question was going to say, pick up a phone and call an intellectual property attorney. And I say that is there are very few topics that require specialization in the law, but this is one. There are attorneys who do nothing but intellectual property. And when I say intellectual property, we are talking about three main things: copyrights, trademarks, and I've even forgotten what the third is.
Patents?
Patents, absolutely. Patents, trademarks, copyrights, depending on whether it's an idea, whether it's a product, whether it's a name that you are trying to protect. But that is its own little boutique segment of the law that we refer to people. And there's nobody in Richmond that's going to be an intellectual property attorney. There's just not that much call and demand for it. So we've got people in Dayton, Cincinnati, Indianapolis that we refer people to for those questions. So unfortunately, if you have intellectual property and want to protect it, I'm going to give you the name of one of those, because I would fear if I tried to give you something off my hip, I'm sure it'd be wrong, and somebody would be calling me up in a few weeks and saying, why in the world did you say that? So I'm not even going to touch that, unfortunately.
And I don't think that there are many intellectual property specialists, and therefore they can be very expensive. What do you think about that?
You have on the market. I know that there are books. I've gone to a couple seminars that it's kind of like intellectual property for the know-nothing attorney, And so I'll look at it and I'll get some idea at the time. And then the next year things change. And so I've just decided, as has everybody in our firm and probably everybody in Richmond, just to stay away from it, because the minute we give some advice, it's probably going to be wrong.
And it can be very expensive to be wrong. So that's great that you're doing that.
Now, having said that, there is a misconception that you have to register on keeping a name. The best way of protecting something is to use that name all the time and create a history of the use of that. Now, I'm mainly just talking about protecting a name right now, is to use that name for it, that the use of it comes into play very aggressively down the line, as much almost as registering that name. So it's going to be much easier to protect it if you use it rather than just keeping it back in your desk drawer or something. So do use it. If there's one clue to do on protecting a name from an intellectual property standpoint, is the use of it.
Good answer. So I need to have specific contracts. I'm just opening my business and I don't really have any idea how I'm going to write that contract. So again, do I need to talk to you about that, or can I go to Dr. Google? How do you feel about that?
I'll be honest, when I saw that question, when you gave it to me ahead of time, I laughed a little bit, because do you know how much that can open the door? I need a contract. Well, that can mean so many things. It can mean, do you want employment contracts for your employees? Do you want a contract with your customers? Do you want it with your vendors? Do you want it with your partners? So the answer to all of those from a lawyer standpoint generally is yes, get it in writing. Let's take each one of those separately. Maybe the employment contract is going to be something in Indiana. An employee is generally an employee at will, meaning that they have no assurance of a time of employment, that either side employee can walk whenever they want. You can fire them whenever they want. And that's a hard concept for a lot of employees. I can remember when I did a seminar years ago for employment law, and my secretary was typing it up, and she came to a point and she came rushing to my office. She goes, "Bob, this says that you could actually fire me for any reason at any time." And I go, "Yeah." And her face just dropped down, and you thought that I had just, shot her dog. That people don't realize that an employment at will situation does allow, you don't have to have a reason. Now, and I know I'm getting off the tangent a little bit, some of that comes back into an employment contract. The exception to that employment at will is you can't discriminate against them. You can't fire them for race, creed, age, sex, other protective classes. You can't do it. But if you just don't get along with some employee anymore, you can let them go. You don't have to have a reason. An exception to that would be if you have an employment contract. So it's probably going to protect the employee more than it is going to be an employer, only because even with an employment contract, we don't have indebted servitude anymore. So if an employee wants out of a contract, you're not going to force him to stay with you. So it's given more protection to the employee. But there is a psychological that employee would feel bound to your company for a year, for 2 years. And more important than the time is it can put in some placements as far as rules and regulations of that employment, even create what are the causes that would allow you bad attendance, being late, all of that, so that there's no gray area as far as what is happening for that employment contract. So there could be reasons for having an employment contract with your employee. So that's one type of contract. And yeah, could you get that online on Google, Legal Google? You could, but boy, on all of these, I'd recommend that you at least run it by an attorney that you know, so they can talk to you about what you're really looking to accomplish there. So that's your employment contract. Do you want one with customers? You may want one, especially if you are selling a product on credit quite a bit. Here's what I'm talking about. People will think that they can, after the fact, tell a customer that if you are late on a payment, I'm going to charge you a finance charge of 1.5% per month. And it's done all the time, and most customers don't challenge it. But if it really gets to the nitty and the gritty and you're going to court, you cannot collect a finance charge unless you have had a customer sign off agreeing to pay that finance charge if they are late on a payment. Consequently, have that contract written by a customer so that you can collect that. Plus, if they don't pay you and you need to have attorney's fees, that's the other thing that is a misnomer. People think that if I don't have anything in writing and I have to sue somebody, can I collect my attorney fees also? Generally, no. The American system is each party, even if you are in the right, has to pay their own attorney's fees. The only time you have the other side, the non-prevailing party, pay it is if you've had a contract that says the non-prevailing party will have to pay attorney's fees. So consequently, it would be good to have that kind of credit agreement or something. You can call it all sorts of things that you would want your customer signing on that type of thing, primarily to talk about what happens if they don't pay. But then there's a variety of other things you might want in that customer contract, so that what product are they actually getting? Are you really making any warranties about that product? If they aren't happy with it, is there a certain time for them to return it? Is there a certain time for them to make a complaint about that product? So all of those types of things could go into a customer contract. Now, I understand the other side of that. PR people will say, if you're trying to make a sale, you don't want to squirrel that sale by giving a lot of writing to a customer and they'll just walk away from you on that. So you're going to have to find a happy ground between what is the ease of selling your products versus what's going to protect you if things go wrong, or to just help clarify the relationship that you have with that customer and what you're trying to accomplish with that customer. Vendors, we'll put this in reverse. Vendors may come to you asking for you to sign contracts, and you may want that from your vendors or who's supplying your material or products to you, so that if they don't get it to you in time, maybe you can sue them for damages. So you want to put in there at what point in time do they have to get that to you. They're going to want to put it in there. When we talked about earlier on who's responsible for the billing, that may be where they put in a personal guarantee if you do have a corporation LLC. So that could be something you don't necessarily like, but be ready for it if a vendor comes. That would not generally be something you would create, but it might be something that's presented to you. You're more likely to prepare the one for your own customers. And then, do you have a contract as such? That term contract could apply to a buy-sell agreement or buy-sell contract that you would have with partners. If you don't have it already in your operating agreement for an LLC, or in a would not be part of your bylaws, but part of an original buy-sell agreement, that could be a contract you'd want to talk about. And this happens so many times that partners who get along perfectly at first, a year down the road don't, and one wants out, they'll come to me and say, what do we do? And I'll say, well, did you have some contracts set up when you went into business when things were still going good? No, we really didn't. And so now it's after the fact, and it can be really difficult. I've seen businesses fail because they did not have contracts set in place while things were going well between the two of them or the four of them or whatever. So that is another type of contract you would want, so that you can show what happens if somebody wants out, what happens if one of the people die. So that's a fourth type of contract you might be looking at in a business situation.
Bob, that's something I always tell my clients, that it's just like entering into a marriage. And how many marriages do we know that didn't work out?
That's
so
exactly
that prenup agreement's pretty important.
Yeah.
I think Roxy had an add-on question there.
Yeah, Bob, this is a question as a hype person I hear a lot. What do you, and this might be way too big of a question, you can break this down, maybe just give a few sentences about what you think. A lot of young professionals are under non-compete contracts. Can you explain why those are important, what they should know about those?
Yep. Okay, non-compete contract in some states are not even enforceable. Indiana is still enforceable if they are very, very carefully put together on that. And the three things that are, well, let's first talk about what is really a non-compete agreement is meaning. It is primarily talking about that, and one is almost a natural, that while you're working with company A, you can't go out and compete against that with another company doing the same thing that would be disruptive to company A that you're working with. I think most people would understand that it's just not right, if you want to call it one way, but it's also not legal. And even without the non-compete, you probably have a fiduciary duty to the company you're working with that even just by natural law, you're not going to be able to go to another company and compete against it. So where it primarily comes into play is after you leave company a non-compete agreement is going to say even after you leave for a period of time, you can't compete with company A. In order for that to be enforceable, you've got to look at three things. Is the time period after you leave, is it a reasonable time period? If you were to say you can't compete with company A for the next 10 years, the courts are going to throw that out. If it's for a year, probably is going to be all right in most instances. So we've got a time element that has to be reasonable. Geographically has to be reasonable based on the business that you do. If all you did was deliver milk in Wayne County, Indiana, and somebody tried to put a non-compete that says you can't deliver milk anywhere in the United States, is just unreasonable. Because company A that you used to work with never went outside the boundaries of Wayne County. So why would they need a non-compete outside? So the geographic area has to be reasonable as well as the timing. And then three, the descriptive work of what you can't do has to be very specific as well. If you were in the milk production business, I don't know why I picked that. Maybe I had milk with my cereal this morning. That if it said you can't produce any groceries of any kind within Wayne County, you've gone beyond what is really necessary for that protection of that company A. So you've got to have specific description of what you can't do, specific geographic, specific time. If you do that, then there is likelihood that that non-compete will be enforceable. Now, I could do a whole seminar on non-compete, but the other thing is there has to have been consideration when you agreed to that non-compete. So there are some ways that an employee can get out of that. If they didn't get anything in return, if they didn't get any assurance of employment when they signed that non-compete, that might be voidable as well. There's also some non-competes that are voidable because of public policy. Some small rural communities that are in need of doctors, there have been some cases where the physician offices or the hospital have put non-competes, and because that community needed doctors so much that was deemed in violation of public policy. So there are some nuances on some non-competes that you would have to look at. But in general, that is there. And of course, when somebody comes in and says, my employer wants me to sign this non-compete, I'll go through this, I'll look at it, and if it's been very well fine-tuned from an attorney, I'll tell them it's probably going to be binding. So you're going to have to make a decision. Is it important enough for you to sign on with this company, even though you're going to have a non-compete on that? And there are some horror stories because it can literally keep you out of business for another year during that period of non-compete. So what you have been trained to do, you can't do in that locality anymore because you signed that non-compete. So the moral of the story is just be very careful before signing them. Don't fluff it off. If you want to seek legal advice about it, see if it is enforceable before you sign it. But it is something not to take lightly. I don't know if that answers some of your question, Roxy, or not.
No, that's great. Thank you, Bob.
So now it's the turn when all those other faces that are pictured here are going to ask some valuable questions. Talk to an attorney here.
One question we received earlier by email, what would you say about things you should consider when going into business with family?
How much do you love your family? It happens probably more than 50% of the businesses that are created with family members. And I would say the best advice to give them is don't just trust a shake of the hand. And I hate saying that because you'd like to think the shake of the hand is good enough in this day and age, especially with family members. But I have found that's especially when it doesn't work out with family members. And that is to get things in writing as to what is going to occur. Even maybe put something in writing where the most common problem is where two brothers, brother and a sister, a parent and a brother, come in and they're each an equal 50% owner. So nobody can break the tie. And they come up with a deadlock. One wants to sell or expand, one doesn't want to do that. And they'll come to me and say, what do we do? Well, generally, the default is going to be nothing gets done because you can't agree to it. So you might consider a couple things. One, well, two or three things. One is making sure one has 51% ownership so they can always outvote the other. So you know at the end of the day, it's what they want's going to happen. That may be difficult. Maybe try to have an odd number so that 2 out of 3 would always vote for it. A third method would be even set up a pre-arbitration method that some trusted advisor to those 2 family members they would go to if they reach that deadlock. We have done that before, but that is so often the problem. The family, that's a problem with it. And as I talked about earlier, when one wants to get out or when one dies, and all of a sudden, instead of that brother, it's your sister-in-law because your brother passed, and now you're dealing with the sister-in-law, you want them to be in there. You could have avoided that by putting in some documents on a buy-sell agreement that before that can happen, you have a chance to buy out your brother. Especially if he passes, you might even want to consider having life insurance to be able to fund that. So it's just think ahead of time, see that attorney, talk about what you might run into down the line with that family member. Also deal with family succession. That's the other problem I find is that parents have run the business. Now they're ready to retire. One of their kids is involved in the business. Another one isn't. How do we fairly get something passed to the child who's been involved in the business and also fairly treat the one who's not? The worst thing that can ruin a business is to have non-involved family members become owners of that business so that they're just looking for dividends and other things, and they end up fighting those who are in control who think they should deserve a bigger piece of the pie. That is, so if you don't have some good business succession planning in place too, that can ruin a family business.
Great, thank you. The next question we have is, besides an attorney, who else should you have on your team working with you alongside starting a business or keeping a business running?
I always tell people you need to have an attorney that's close to you, an accountant that you trust on giving you this tax advice, whether it be how to set up which company, LLC or corporation, how to handle employment, how to handle retirement plans, have an accountant, have a banker that you can trust where you're going to set up your bank accounts because you're likely going to require a loan, if not right at the start, sometime down the line. So if you have a banker, an accountant, and an attorney, is a really good start on that team.
And make sure you have Peggy, right?
Oh, of course, yes. And most importantly, you join the chamber. So
yes, that's true too. You need the chamber in the corner. Peggy, do you have any questions right now?
No, but I just would like to say how valuable all this information has been to me, and I'm sure to our other listeners. I would say that the what ifs that we don't think about because we're in love with our new business are the biggest problems. And that's where Bob could come in handy to say, what if? And I always say when you have another partner, you're in partnership with their spouse as well.
that's true.
So you just don't know where it's all going to go. And that's why it's very valuable. I'll have it thought through ahead of time. And do we have other questions here? Let me see.
If you have any, talk about a chance to get free legal advice. You're right here. Although, no, I should give a disclaimer. None of this is legal advice for your own particular situation. This is all generalities. So you cannot count on this as a legal advice and you come back and it haunts me. So I shouldn't say that wording. This is a chance just to ask some general questions.
Yeah, it's a great chance.
Yeah. Bob, how do you recommend employers minimize any risk they may be taking on?
Well, I'm not sure how to minimize any risk as an employer. What means?
Yeah. So if they, I'm thinking like, how do they know? Like, maybe it's just having those people in their corner? Do they need to? What can they do? Who can they work with to make sure that they're not putting themselves at risk?
Well, I think you need to know the laws, and a lawyer is the one that should go to for the laws. But then there are other organizations like we're talking here to find out because there are so many rules and regulations, safety things, as far as, especially with and I have to ask the accountants all the time too, as far as what are the reporting requirements for withholding taxes and sales taxes and all of those types of things that are really outside of what we do that your accountant can get done. So when somebody comes and says, I want to start a business, what do I need to know? We'll give them what we know, but then send them to the accountant so that they are doing things correctly with the state employment agencies and workers' comp. And, oh, I suppose I'm going to add a fourth member to the team. You ought to have somebody from an insurance standpoint, have a good insurance person so that you have insurance in place for your employees, for your business. So let's add that fourth member of the team as well.
Bob, it's like you're reading Peggy and mine's mind, because next month is going to be Ask Your Insurance Agent. So last month was Ask Your Banker, and this month Ask the Attorney. We're building that team for you and giving our small businesses a chance to talk to these professionals that they need in their corner.
Sure.
Bob, before we finish up today, I'm going to give you a second to promote BBFCS. BBFCS. It's a mouthful. Tell us a little bit about where you're located, how people can connect with you if they do have follow-up questions or if they're looking for an attorney.
Absolutely. Well, let me first just give some of the names. We have Rick Boston, Ron Cross, Bob Bever, Walt Chittister for a little bit longer, although he is given his notice of retirement later this year. Adam Forrest, AJ Sickmann, Doug Oler. Our primary office is at 27 North 8th Street in Richmond. We also have a satellite office in Cambridge City on Foot Street that we each take turns going over there, although I'm the primary go-to person over in Cambridge City, so we can serve Western Wayne as well. And our law firm, the current people have been here since '98, but the firm traces back to 1911 when it was started by Denver Harlan, Adam's grandfather, actually. And so we've been in existence for over 100 years through successive names throughout that period of time. We've been in our current location since '98, so we're talking about 23 years here. We have just an invaluable years of experience from all of the attorneys. Getting ready to add a couple associates here, hopefully. Finding someone to come to Richmond is always a challenge out of the law schools. They'd rather stay in Indianapolis rather than come to some of the county seat towns, but we have a couple hopeful possibilities now. So we can represent a variety of things, whether it be divorce law, business law, of course, estate planning administration. We represent a good number, if not almost all, the municipalities and schools in Wayne County and Eastern Indiana. So we think we can almost answer any of your needs, even some criminal. Prior attorney did criminal work, did retire. So we're not as involved in that as have in the past. Personal injury cases, handle those as well. So all of those kind of needs can be taken care of, and you can contact us on our website at BBFCS, www.bbfcs attorneys. Give us a call. We're happy to help in any way and can almost get somebody in the same week anytime that you call with any kind of legal need that you have.
Great. Thank you, Bob. I do want to remind all of our participants today that there is a survey link in the chat box right now to take. This provides us feedback for other programs that we continue to host throughout the year. Before we head out, though, I do want to give a thank you to Bob and Peggy for moderating and Bob for donating his time today to us. He's been a huge support of the Chamber. As he said, a board member for, I think he said, over half of his life. Bob, we appreciate all the work you do.
Approaching 30 years. So.
Over 30 years. It's just incredible. He's always a source of reality for our board and brings us and makes sure that we stay in check. So we appreciate all the work he does for us. I also want to thank our sponsors again. We are so thankful to have all of them sponsoring this session each month. And thank you all for being here. Thank you to WETV for sharing this video and making sure that our small businesses are taken care of. Peggy, anything else you'd like to say?
Oh, just that we at the East Central Indiana Small Business Development Center really love working with the Chamber and with all of Wayne County, and that what we do is at no expense to you, no cost, because you've already paid for that with your tax dollars. So we have a pretty good value there.
Thank you, Bob. And thank you, Peggy.
Thank you, Roxy. Appreciate the opportunity to help out.
Thank you. Everyone have a great day.
Thanks.